Good morning. I appreciate the opportunity to speak to you this morning. My name is Kevin Bond with Manor Ranches, Texas for Judicial Accountability. The OCA has created a program, the Guardianship Abuse, Fraud, and Exploitation Deterrence Program, the GAF-EDP. It has played a vital role investigating guardianship issues in Texas. The GAF-EDP has collected evidence of abuse, fraud, and exploitation in state guardianships. It reports these findings to the judges overseeing them. When we submitted a complaint to the SCJC regarding two judges failing to follow mandatory reporting law, the SCJC considered this judicial discretion. It is highly suspected that these two judges in charge of guardianship never reported the financial exploitation within the guardianships to DFPS. This sets a very dangerous precedent for the vast number of cases which the Commission doesn't hold judges accountable who are in breach of mandatory reporting laws, failing to report the CPS or APAs the exploitation and abuse occurring within their jurisdiction. When the SCJC is made aware of the documented exploitation of a handicapped ward, why doesn't the SCJC prioritize these vulnerable individuals who can hold judges accountable? Why is the SCJC enabling judges to disregard abuse of handicapped wards in the name of judicial discretion? Everyone, please do not miss the fact that the investigation and audits have already been done and are sitting in the GAF-EDP records. The SCJC refuses to request these filed audits of mismanaged and exploited abusive guardianships. The following are two examples of GAF-EDP findings. 1. The GAF-EDP audited the $18 million estate and $18 million estate. Despite poor record keeping, they found unapproved loans totaling $1.3 million, over $200,000 or $20,000 in unauthorized charitable donations. The state statute requires a guardian's bond basically to equal the value of the estate. The court-approved bond was $120,000. For an $18 million estate. There was no judge intervention. The guardianship was the subject of our first complaint to the SCJC, which denied due to judicial discretion. Another guardianship case. A ward had co-guardians who never had visited in 31 years. No ad litem was ever appointed. Where were the judges over these 3 decades? Once the rights of wards are violated, especially with the broken statutes, no ad litem or other valid representation, the SCJC is the only safety net left for the ward. When we made a complaint in 23, quoting the exact information, the GAF-EDP 2022 report guardianship, the SCJC turned down the complaint due to a lack of a judge's name. The SCJC could, with one phone call, get this information. We need these addressed.